TNS Radio.
Land of the free, home of the deluded, according to Keith Rooney, a practicing barrister working in debt recovery, personal injuries and company law. This article, page 12, I believe, Law Society Gazette. The free man on the land ideology may appear harmless in many respects, but Keith Rooney argues its delusional approach to legal issues is a growing cause for concern. He doesn't say who the cause of concern is to exactly. Perhaps it's him privately. Also, by claiming it may appear harmless, I think he's suggesting that it is dangerous, which is kind of strange considering that the free man on the land philosophy and ideology is all about no harm, loss or injury. Perhaps Keith might benefit from talking to some of these men and women. Anyway, on the 24th of February, the article reads, star of the YouTube video, and here's the biggest clue, Constitution halts sheriff. Constitution halts sheriff. Okay, maybe Keith missed that bit. Now, Ben Gilroy didn't use any free man on the land methodologies, as far as I know, just like most of the guys here on TNS Radio. We don't hold a lot of truck, if you will, with a lot of the things that the free men or the free man on the land ideology, supposedly, or philosophy, holds. We just don't think a lot of it makes sense, to be honest, quite frankly. So in that regard, I'd like to say thank you kindly to Keith Rooney for producing this wonderful article, which is, well, I'm going to continue to just pick my way through, and let's see where we go from there. The methodologies he used are common strategies of a group known as the Free Man on the Land. You see, that's underneath Ben Gilroy, and Ben Gilroy certainly didn't employ any of those methods from what I can tell. He then goes on to construct an elaborate straw man argument. I say straw man argument because it really has nothing to do with the content of the video Constitution halts sheriff with Ben Gilroy, where the opening paragraph would suggest they are completely unrelated issues, and Bobby Sludds did not use the Constitution as Ben Gilroy did. Anyway, we'll continue. The Freeman movement is one based on a number of conspiracy theories, such as the belief that birth certificate creates a legal fiction in your name. No, that's not what the Freeman movement is based on. You see, if you're going to say what it's based on, the clue is kind of in the title. Free man. It's based on the assertion that man is free, you see. Maybe Keith missed that bit. And such as the belief that birth certificates create a legal fiction. No, that's a group who use what is commonly known across the internet, if you'd care to check, known as commercial redemption. And they are basically a separate group known as, guess what? Commercial redemptionists. So nothing to do with free man on the land either. And by the way, just as a side note there, I have nothing to do with free man on the land either. That whole thing is, anyway, we'll get there later. Now, apparently, they believe this fictional entity to be a corporation, yada, yada, yada. You can read on down through there. Again, mostly nonsense. Now, interestingly, here it says there is also a belief that the bar is an acronym for British Accredited Registry, and that all barristers swear an oath of fealty to the English Queen. And he stops right there. He doesn't explain what the bar does actually stand for. He doesn't offer any suggestion as to how or where that may have come from. And he certainly doesn't mention, or he certainly doesn't give the reader any idea as to what it may mean or where it may come from. So, that's like saying I was on a bicycle yesterday and moving into a different sentence. It just doesn't make sense. Then he says, while this is the tip of quite a substantial iceberg, it may be more valuable to look here at the approach of the free men in a practical context. Okay, well, he sees a practical context, perhaps. The basic premise, always back to the basic premise of the free men comes from a literal belief. Are you sure you don't mean an actual belief, Keith? Not a literal belief, or perhaps I suggest a belief. that no man may be governed without his consent. So is Keith Rooney, practicing barrister, saying man can be governed lacking consent? Is that I would like Keith Rooney to clarify that, please. Is he suggesting man can be governed lacking consent? If that's the case, let's scrap the elections tomorrow. Let's not bother voting. I mean, the government and the barristers and the solicitors, they all know best for us, folks. Let's stop all this silly wasting of time with voting and consenting to what the government offers to us or suggests or seeks our approval of. Let's not bother. Keith Rooney knows the way, folks. Feel a dictator coming on. Anyway. Therefore, if I do not consent to a law, it does not apply to me. They believe that statute law is actually admiralty or maritime law and does not apply to the people or, and interestingly, or civil matters. No, they don't say that. They do not say that. They believe that statute law, or some of them may believe that statute law may be admiralty or maritime law. But to be honest with you, most of them just call it commercial law at this stage, Now, then he suggests in brackets, perhaps he's afraid to state this too boldly. Proof, he claims. Proof for this comes from apparent maritime phrases in courtrooms, such as, and he picks one word, dock, D-O-C-K is how he spells it, and he then says the word actually derives from the Dutch dok, D-O-K-K-E, meaning an animal pen. An animal pen. So, okay, so Mr. Rooney here, Mr. Keith Rooney apparently, seems to think when people are asked to step into the dock, they are being asked to step into an animal pen. Is that what you're saying there, Keith? Please consider clarifying that one. And that common law is the law of flesh and blood human being. No, wait a minute. And that common law is the law of flesh and blood human being. I'm assuming there should be an S there, human beings, or law of the land. No. On the land known as Ireland, which with a name like Keith Rooney, I'm assuming you were born on, I think it'd be fair to say most people would say the common law of Ireland was Brehon law. And common law would be referring to there would be English common law, as stated quite clearly by President Mary McAleese on the Queen's visit. In fact, it's in one of her speeches on the on president.ie website. You can go check that one, Keith. I'll leave that for you to check. Now, if a free man finds himself in court, he is likely to take one of the following approaches, which is a bit strange here because he said the first one is not turn up at all. So if a free man finds himself in court, he is likely to not turn up at all, therefore not finding himself in court, I suggest. So, okay. Question the judge as to his standing or attack the jurisdiction of the court. Now, questioning the judge, the supposed judge, as to his standing, well, again, he's just a man, right? He's just a man. So the guy wants to check, basically people are posing these questions. They're asking questions. And Keith Rooney apparently doesn't like anybody asking questions of a judge, or at least not questions he would ask, because he, of course, accepts all of this. Now, attack the jurisdiction of the court. You see, there's a lot of inflammatory language in here. Land of the free, home of the deluded, number one. And now it's all about tack and is this dangerous, or they may appear harmless, right? So I think it's very clear what type of an article Keith Rooney is attempting to construct here, or indeed has constructed. I'll go on. I'd like to know exactly where Keith Rooney, practicing barrister, thinks the jurisdiction comes from, or how it's obtained. Subject matter jurisdiction is a fascinating topic, folks, and I highly recommend reading up on it. And in fact, I highly recommend reading the material I suggest Keith Rooney has probably read on it for some valuable insights. Now, from our own correspondent, while simply not turning up in court, while simply not turning up may not appear as a novel strategy in itself, it is the manner in which the free man does it that makes it worthy of note. So the manner in which he doesn't show up. Okay, I don't know how you can have that, but anyway. This particular approach is most often taken for various forms of on-the-spot fines or fixed penalty notices. Typically, the free man will engage in some form of correspondence, usually with the authority issuing the original fine and/or the district court clerk for the appropriate area. This correspondence will dispute. No. Pose questions, I believe, is the correct term. This chap, Keith Rooney, whoever he may be, if indeed this article was loosely thrown together ad hoc by Keith Rooney, who, if he actually is a barrister, wow, I would not be a happy bunny if I had this chap taking care of something for me. Dispute validity of the fine. No question. They question. Normally stating no valid contract has been entered into. Well, is he suggesting there's no contract required? Even the social contract, is he suggesting no such contract is required? Because if so, I'd be very interested in Keith Rooney, practicing barrister, coming on TNS Radio perhaps for an interview to discuss this in depth. In fact, I invite him. I'd be delighted. I would also take note that, of all the articles that seem to appear out there, nobody ever mentions TNS Radio, because we just use logic and reason, folks. That's all we employ. We're not making any claims. We're just making and asking questions. We just ask questions and we pose things and we say, hey, how about this and how about that? And we discuss, you see. Now, he then goes into the straw man's statutory obligations. Red thing there with the Freeman Guide state. Well, what Freeman Guide? Which Freeman Guide exactly is he referring to there? I don't know. So, again, it's a straw man argument, as Ben Gilroy, who gets a mention in the first paragraph, hasn't been mentioned since, and all they're trying to do here is to attach all this junk to Ben Gilroy. We'll go on, second page, and there's an image of, actually that's interesting, because that image, actually that's interesting, because that image appears to be a screenshot from the video on YouTube, and if so, I think the Law Society Gazette may be in breach of the publication guidelines for YouTube. Yes, indeed, I think they are. That video was released under a very precise YouTube license. How interesting. Anyway, we'll go on. Now, then they go and get into the family sludds, Kenny sludds. Again, another complete strawman argument, has nothing to do with Ben Gilroy whatsoever. Moving on, bizarre approach. Apparently, the approach is bizarre. Well, I'm sure it's bizarre, perhaps, to Keith Rooney. That's fine. In this way, the free man believes that if a judge has not produced his oath, this is in relation to the oath of office. Okay, right. I'll go back a little bit. He is. I actually think he's correct about the oath of office in this regard, where Kenny Sludds was asking about the oath of office, or asking the judge apparently to produce his oath of office, and asking the judge to. Sorry, he says this is based on a misreading of Article 34.5.3. Okay, well, what we'll do here, 34.5.3, interesting. Let's have a look at that. A misreading of Article 34.5.3. And just so we're clear, English text, the declaration shall be made and subscribed by every judge before entering upon his duties as such, and in any case not later than 10 days after the date of his appointment, or such later date as may be determined by the President. Now, the direct literal translation from Bunreg na HÉireann, Mícheál Ó Carúl's direct literal translation. Every judge must make the declaration and put his hand to it before he takes up the responsibilities of the duties of his office, and at any rate on a date not later than 10 days after the day of his appointment, or a date which is later than that, as the President will decide. Yeah, I think that's fair enough. I think, in fact, perhaps Keith Rooney has made an actual correct assumption. What it's got to do with Ben Gilroy beats me. Anyway, we'll continue. In this way, the free man believes that the judge has not produced his oath or refuses to do so, yada, 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 yada. Then he has, oddly, the free man does not seem to follow this road too often, preferring an utterly, now get this, utterly bizarre approach where the free man accepts the oath of the judge, whether one is forthcoming or not. So he thinks it's bizarre to say to a man who's clearly entered office in some way, shape or form, it's bizarre to let them know you accept and acknowledge their oath of office. Well, I don't see why that's utterly bizarre. Perhaps Keith Rooney would suggest a reason as to why that's utterly bizarre. You know, I await the response. This, in the free man's world, forces the judge to uphold common law. No, 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 no. How could it? How could it? You're accepting and acknowledging his oath of office. So you're accepting that whatever he has sworn an oath to uphold and keep sacred, if you will, you're saying, I accept it. And, you know, you're just letting him know. Surely that's just being polite. Disregard statute law completely. How interesting. Now that's an interesting turn of phrase there from Keith Rooney, as if he'd care to take out a copy of Bunreg na HÉireann, which I suggest he goes to the direct literal translation as well, and have a look under Article 41.1.1. Now 41.1.1, I'll give you, I'm just scrolling down to here myself. Here we go, Article 41.1.1. English text. The state recognises the family as the natural, primary and fundamental, mind you, unit group of society, and as a moral institution possessing inalienable and imprescriptible rights antecedent and superior to all positive law. Now most people might not really get that. A barrister would, surely. Anyway, we'll go to the literal English translation of the Irish, as I'm sure everybody knows. Under Bunreg na HÉireann, the Irish language takes precedence, which it clearly states in there as well. Literal English translation. The state acknowledges that the family is the basic primary group unit of/for society, according to nature, and that it is a moral institution which has inalienable, invincible rights which are more ancient and higher than any human statute. That would be any human statute. In other words, Article 41.1.1 clearly demonstrates, or reads, or suggests, or states, whichever way you want to look at it, and I would be most interested in Keith Rooney's learned opinion on this, but it's clearly suggesting that the family has inalienable, invincible rights, higher than any human statute. Any, not just the Irish government's statutes, any human statute. Any. How interesting. Now this bit at the bottom here, under whose authority? That's a good question. That's a very good question. And he suggests it may be instructive to look at the approach taken by Stephen Sutton on 20th of May 2010 before Kilcock District Court. I suggest that would be very instructive, in fact. Now, there is a recording out there that was sent to me, and I'm going to give a little example of it on this. It wasn't actually sent to me. It was, I think it was downloaded from the Freeman Ireland website, because that's where Stephen Sutton was doing whatever he was doing. And Judge Zidane acknowledged the sovereign Republic of Eire when Stephen Sutton mentioned it to him, and he did say it to him. Judge Zidane accepted. Now, interestingly, if one, and again, I suggest Keith Rooney investigates or examines this issue, above the judges in the courtrooms is the sovereign seal. Some people call it the harp, but it's not. It's the sovereign seal of the sovereign Republic of Eire. 13 strings. The 13th string, sovereign seal, represents the torque of Moran, the collar of truth, and it's the death penalty for the judge if he makes a bad decision that hurts or harms a man. It's for its execution, loss of assets, etc., etc., to the man. And I don't know if they know or if they realise they've been sitting under that. I suggest they do. But Judge Zidane apparently accepted that. Interesting. He also goes on to say Stephen Sutton mentioned the Gaelic version of it, not the Blue Book masquerading as the true text in all outlets, which is why I talk about the direct literal translation, which of course is a government publication, folks. This is not a conspiracy theory, or is he suggesting that the government publications office produced their own conspiracy theories? Interesting. Okay, he goes on and talks about referring to An Garda Síochána, agencies, fixed penalty notices, yada yada yada. Oh yes, then there's this. The free man, if he has accepted the judge's oath, now refused to plead. I don't think so. Usually, from what I can find out, or from what I've been told, they don't refuse to plead. When asked to plead, they ask, is it civil or criminal? They make an inquiry, or an enquiry, if you will, a question. They're trying to find out, what is this, a civil matter or a criminal matter? Now, okay, well, look, we'll leave that where it is for the moment, and we'll go on. He then talks about understanding, and he is literally standing under the judge, and thus in his power. No, under his power, basically, is what the free men think, I believe. The third common tactic taken by a free man is to attack the jurisdiction of the court. So free men, by asking a question, are now apparently attacking. So if I ask a stranger, what time is it? They can respond, don't you attack me? Is that the rationale being used here? How unusual. So apparently now when you just say something, you are attacking. Delaying tactics. It is tempting to see the free man as harmless in many respects. So this is the kind of conclusion, if you will. And again, I fail to see what any of this has to do with Ben Gilroy. It is tempting to see the free man as harmless in many respects, but in March 2010, about 300 free men surrounded a court in Merseyside. That's Birkenhead, by the way, folks, if you want to look it up on YouTube, where a number of activists attempted to arrest a judge who had previously declared a local free man bankrupt. Well, no. The man that was declared bankrupt never claimed to be a free man. And the activists who are in the court were mostly, from what I can gather, members of a website called TPUC. And they were in what they would describe as, at the time, lawful rebellion. They were rebelling, you see, because they're subjects of the crown over there, and they were in lawful rebellion. They claimed at the time, I believe, under Magna Carta. So again, maybe perhaps Keith Rooney needs to do a bit more research. Also, interestingly, there were some very significant members of BNP in there in the courtroom. And I would be very interested in hearing why the BNP were there. They seem to get involved when I would be pretty darn positive that the men and women who were there on the day from TPUC would not want to have anything to do with the BNP. So that is interesting. He goes on with his supposed conclusion, or summing up, if you will. He talks about the superior courts in this jurisdiction. This jurisdiction being which one exactly, Keith Rooney? Are we talking about the Republic of Ireland, the Sovereign Republic of Eire? Is he talking about the 32 counties, the entire island? What exactly, please, are you referring to there? And he would suggest the superior courts in this jurisdiction, which, if he's talking about the superior courts, I'm assuming he's talking about the provisional government, which is, apparently that's what's in place in the Oireachtas at the moment. They are a provisional government, and they accept this. Apparently it's in their publications. I suggest there's a very good book, De Valera's Constitution and Ours, Thomas Davis Lectures. It's an RTE publication, edited by Brian Farrell. I'll give the ISBN number, make it easy for Keith Rooney to find. 0-7171-1612-3. Gill and Macmillan. And I suggest that he has a read of this book. This is a very interesting book. And page, where are we on? Yeah, page 18, for example. In 1938, Ireland was still getting used to its brand new constitution. De Valera's Bunreacht was not the first effort to provide a fundamental law for the Irish state. It replaced the constitution of the Irish Free State, which of course was under King George, and that in turn replaced the constitution, the often forgotten constitution of Dáil Éireann, drafted in 1919, which was drafted in 1919, Vaughan's Hotel, Parnell Square, Granby Row. So I think Keith Rooney needs to do some homework. Anyway, again, the summing up really doesn't relate to Ben Gilroy in any way, shape, or form. So basically, I think I'm sure many of you would agree, Keith Rooney basically is responsible for offering up to the Law Society what's known in the world of newspapers or journalism as a hatchet job. So he mentions Ben Gilroy, the Constitution, at the beginning, and then goes on a diatribe of straw man arguments, offering some interesting food for thought, however, bearing no resemblance or association to Ben Gilroy. I would be very interested in Keith Rooney's response. If you would like to contact tnsradio.com or tnsradio.ning.com. Over Skype, you can use VINCENTTEMP and the digit 1, no spaces, or 00353 144 33309. That's a Skype phone number. Or send an email, or sign up and ask some questions, get to know a few folks there on tnsradio.ning.com and see what we're all about. Okay, so there you go. My intention in this was to hopefully assist some in clarifying or seeking clarification or seeking a solution to this and all that comes our way.